1995 CAM LLC versus West Side Advisors.
Good afternoon, Your Honors. May it please the Court, my name is Steve Shackman of Lambert and Shackman, here for the defendant's appellants. Your Honor, may I please reserve 2 minutes for rebuttal?
Yes.
Thank you. The guarantee here, which is the subject of this case, was a limited guarantee, and the condition which must be met to effectuate the limitation of the guarantor's personal liability is that the tenant had to surrender the premises in a prescribed manner. And the key word is surrender. The error of the court below, we maintain, is construing paragraph 25 of the lease, which is the no waiver clause, in a manner which conflates surrender and acceptance, which are two separate facts and two separate legal
How does the
concepts.
lease impact your argument?
I'm sorry, Judge?
How does the terms of the lease impact that?
Well, because, and this is the whole point of the case, that the guarantee says that the tenant must surrender possession pursuant to the terms of the lease.
Mm-hmm.
And the landlord's argument, and what the court adopted, is that that was not met because there was no acceptance of the surrender under the no waiver clause, paragraph 25. In all other respects, it's undisputed by everyone that the surrender by the tenant complied with all the terms of the lease.
So factually, sorry, I didn't ahead of you. Factually, what did the tenant do to surrender?
Okay. The first thing the tenant did was it served a 30-day notice of its intention to surrender.
That in itself isn't surrender, right?
No.
Okay.
That was part of the process. In other words, the guarantee, the good guy provision of the guarantee.
I'm just asking the facts.
Okay.
What are the facts that you would point to, the
Well,
things that constituted the surrender? What that the tenant did?
Tenant first served a 30-day notice on the landlord. And that notice said, we intend to, pursuant to paragraph 9 of the Second Amendment.
So would you
which is
have
the
to do that
guarantee,
to be a lawful surrender? Would you have had to do that?
to comply
send
with
the
the
notice?
limitation in this particular guarantee, yes.
Okay. So then the next thing that was done, but that's not sufficient, I take it?
That's not sufficient.
Okay,
That's the
so then-
first step under the
okay.
language of the guarantee.
Next?
The next, the tenant completely vacated the premises.
That's
Room clean,
essential.
That is essential also.
And it's sufficient?
Under the language of the guarantee, yes, that's sufficient.
So that's all you had to do was to send the notice and vacate?
That's correct.
That's it?
That's correct. Correct.
Did they do anything else?
No.
Okay. So then
Well, they
how
also
do-
delivered the keys, but that's not essential to our argument.
Okay, so how do you deal with the end of paragraph 25, the no waiver provision that says, "No employee of owner or owner's agent shall have any power to accept the keys of such said premises prior to the termination of the lease, and delivery of keys to any such agent or employee shall not operate as a termination of the lease or a surrender of the premises." It doesn't say an acceptance, it says it's not a surrender.
That's a good point, but that's not all we did. In other words, we served the notice.
Well, I just asked you everything you did, and you gave me two things that were legally sufficient to constitute a surrender.
That's right. Under the guarantee, what we had to do to get out and eliminate the continuing obligations of the guarantor
Yeah.
was to serve that notice and vacate.
But I thought
Did
your
you give
argument...
the keys?
Yes,
Your argument is, as I understood it, that under the terms of the lease, a surrender and acceptance are different legal concepts.
correct.
Right. So the thing that you, I think, in your papers didn't address is that last sentence I read you, which doesn't talk about acceptance. It says it is not a surrender to simply deliver the keys. That's not a surrender.
That's correct. But that's not all we did.
You mean you also vacated?
We
and
also
sent the
vacated,
notice?
and we also delivered the notice, which is the limitation set forth in the guarantee of what the guarantor had to cause the tenant to do to end the liability of the guarantor. So the acceptance, the delivery of the keys
Yeah.
alone, for sure, that's not a surrender. It says it right there in the lease. You're
What is a
100% correct.
surrender under the lease? What's a surrender?
A surrender is the delivery up by the tenant, the yielding up by the tenant of exclusive possession of the premises.
Is that a
That's what
surrender under the lease, or is that a surrender under the good guy guarantee?
That's a surrender under the lease and a surrender under the law. And in this case, pursuant to the language of the
But what
good guy
about the language
guarantee.
in the lease that requires acceptance of the surrender?
It doesn't require acceptance of the surrender to eliminate the liability of the guarantor. And
Well, that's the question,
No,
right, is
but-
what does pursuant to the terms of the
He
lease
asked you if that
mean?
was a surrender under the lease, and you said it was, but
Well,
there's
it was.
language in the
It
lease that
wasn't a-
requires more.
Well, it would require more to eliminate the liability of the tenant.
Well, that's the question before us.
That is the entire question.
Okay,
In paragraph
so-
25 of the lease, excuse me, Judge, sorry.
Go ahead.
Paragraph 25 of the lease, in what it says and also what it doesn't say, is the key. What paragraph 25 of the lease doesn't say is that there can be no valid surrender unless landlord signs a writing accepting the
Well,
surrender.
It does say pursuant to the terms of the lease,
What
yes?
The guarantee, yes.
Yes.
And that's paragraph 22, which
Yes.
talks about the delivery.
Does every good guy guarantee incorporate the lease in that manner, pursuant to the terms of the
I can't
lease?
speak to every good guy guarantee, Judge. No, I
Well,
would say
can-
no. I
can
would
you-
assume no.
I mean, wouldn't the case be substantially different if that pursuant to the language of the lease language weren't in the guarantee?
No, for sure, it would be a different
Well,
case.
your adversary
Doesn't the
says,
paragraph suggest, because it requires an acceptance, and I don't see anything in there that says this paragraph, maybe I missed it, is limited to the tenant, but if it requires an acceptance, doesn't that mean that all you have is an offer? An offer
Yeah,
of a surrender?
It does. And so what we're talking about two different things. And I think this is the fundamental issue. A surrender and acceptance are two different things. A surrender is the tendering, the yielding up by the tenant of exclusive possession. If the tenant does that, the landlord has an option. The landlord can say, okay, that's nice, and I'm going to sue you for the rent. That's the Holy Properties case and the Centurion case. Or the landlord can accept the surrender, accept the tender, and thereby convert that bilateral, unilateral act of the tenant into a bilateral agreement between the landlord and the tenant terminating the lease. And that is what the court below said would have been necessary in this case to eliminate the liability of the guarantor. Now, it would have been necessary to eliminate the liability of the tenant, for sure.
So
But
your
not so for the
main-
guarantor.
Your main point is that the guarantee requires surrender. The provision in Section 25 of the lease goes to acceptance of a surrender. So when you surrender, you surrender. Acceptance is a separate issue.
That's right.
Okay,
And
but
paragraph,
why then would it say, then you would have to read it as completely vacated and surrendered, completely only applies to vacated, right?
no, the
What's
surrender.
completely surrendered?
No, the
then?
surrender is the tender of possession. That's what the
Yeah, but
good guy
what's
clause required the
completely
tenant to do.
surrendered?
I'm sorry?
What's completely surrendered? Add
It
to
just
that
means,
then.
it means to completely get out, lock, stock, and barrel, move out,
But
rule your
You
subtenants
just told me
out.
surrender means something different than that. What's your definition of surrender?
Surrender is the yielding up of vacant possession.
So then what's complete surrender?
Well, I think where this lease talks about, this lease talks about completely vacated and surrendered.
So you think that only
Excuse me, Judge,
modifies
please, it doesn't,
vacated?
I misspoke. It doesn't say completely surrendered. It said completely vacated and surrendered. So the tenant has to be completely out. And all the persons who were in the premises by, through, and under the tenant
Yes,
have
but
to be out.
paragraph 25 says the surrender has to be accepted.
Okay.
That's why I asked you.
Yeah, no,
It doesn't, if the paragraph says acceptance of a surrender, imply that there is an offer of a surrender.
But paragraph 25 doesn't say that the absence of an acceptance negates the surrender.
so what
Avoids the
meaning then
surrender.
do the
How can that
words?
be? How can that be? No act or thing done during the term hereby demise shall be deemed an acceptance of a surrender.
Acceptance
There's
of a
no surrender.
Look at what it says. It says that no agreement to accept such surrender
Right?
shall be valid unless in writing. So that language
I think
assumes.
I agree it would perhaps have been technically more accurate to have said offer of a surrender.
Oh,
I don't disagree with you there.
call it what you may. The
Otherwise,
tenant-
I don't know what, and you agreed with me that, yes, if it says acceptance, then there is an offer.
Yeah, the surrender is an act, and it's also it's an offer, and it can be accepted by the landlord and thereby terminates the liability of the tenant. But that's not what was
It says surrender
required.
pursuant to the terms of the lease, yes?
Yes.
Okay, so what meaning, under your reading, do the words pursuant to the terms of the lease mean?
It means paragraph 22 of the lease, which talks about, well, it's entitled end of term, but that's the paragraph that talks about what the tenant must do
And why
to
does the
surrender
no
the premises.
waiver, why does the no waiver clause not also count as terms of the lease?
Because the no waiver clause doesn't go to, has nothing to do with surrender. It
Well-
only speaks to acceptance of a surrender. So in other words, if you look at paragraph 25, it says no agreement. And this is the whole
No,
thing
it
right
says
here.
no
really.
act or thing shall be deemed an acceptance of a surrender,
Yeah.
and no agreement to accept shall be valid unless in writing signed by the owner.
Paragraph 25 has nothing to do with the requirements for a surrender. It has to do with the requirements for acceptance of a surrender. It does not say, and this is the error, it does not say that there can be no valid surrender unless there's a writing signed by the landlord. What it says is that...
What does a valid surrender mean if it is a
Excuse me,
surrender?
I misspoke. It says that there can be
If
no
I ask
acceptance
the
of a
question,
surrender.
What is a valid surrender if there is no acceptance of the surrender? What does
It's just-
that mean conceptually?
Conceptually, it depends on the party's agreement. And in this case,
Well, under
it
this
means that,
agreement.
under this agreement, it means that the tenant is certainly on the hook for the rent. The lease has not been canceled or terminated. The lease continues, but the guarantor is off the hook.
Wait, Where in the lease do you see that the acceptance of the surrender terminates the lease?
I don't see that in the lease. That's just the law.
Well,
Acceptance of
the
a...
lease says that you've got to pay for the full term, and the term is 7.5 years.
Right.
And there's nothing in there that says the acceptance of the surrender relieves you of the obligation to pay for the term, is there?
Not in the lease, but I would respectfully refer you to the case law. It's the Holy Properties case and the Centurion case, which says that if the landlord accepts the tenant's tender of surrender, the lease is thereby canceled, and the tenant does no further liability. That's the requirement to end the liability of the tenant, an acceptance of a surrender. Paragraph 25 talks about what's required.
Otherwise, the landlord has the property and the money,
That's right.
and that's at the foundation of that case law.
And the incentive, the reason for a good guy guarantee is it incentivizes the guarantor, who's typically a human being who has some control over the tenant, to ensure that if the tenant is not paying and not able to pay, the tenant gets out and the landlord has the space back. The tenant is, in that way, a good guy, so to speak, and doesn't hold up the landlord, it hold up and stay in possession. The reading by the court below...
You can agree that perhaps it might have been crystal clear if the paragraph about what the guarantor guarantees, right, about completely, and the tenant shall have completely vacated and surrendered the premises, that demised premises to owner. It could have said, regardless of whether the owner accepts the surrender.
I mean, yes, Judge, but a lot of things could be negotiated in the leases.
Yes, but you
Yes.
pointed out, I thought, for some other paragraph, that we should be concerned not only with what is written, but what is not written. So
Well,
I'm suggesting that
that's right.
perhaps
What-
the failure to include that language does not support your argument.
I think that...
And it would have been easy to include it.
With a lease, Judge, that may be true, and I can't speak to the drafting and what went into that and what was negotiated and what...
But these are REBNY forms? Was
But this
this
is
language at all changed from
Exactly.
the
This
REBNY form?
is a REBNY form.
Okay.
Wait a minute,
And-
your adversary says that the guarantee itself is not a standard remedy form.
That's
Do you-
correct.
Okay.
The guarantee-
So- Okay,
But that's what we're concerned with.
yes.
Well,
What's different in this from, is there a REBNY guarantee form?
I'm sure there is, but this is not what they use. And this is a revenue guarantee form is typically a full-blown guarantee, not a good guy, not a limited guarantee. Everybody, and by the way, everybody
So REBNY
agrees.
doesn't include a good guy guarantee in its form.
I don't know offhand, Judge. I don't know, maybe perhaps there is one, perhaps there
That's
isn't,
fair.
I don't know. But what I do know is that the language of this guarantee, the limitation language where it talks about a 30 days notice, and it goes on to say the condition of the premises, that language, like any language in an agreement, must mean something. It can't just be superfluous. And the reading of the court below makes it superfluous. What the reading of the court below does is say the guarantor is not off the hook unless the landlord, at its whim, decides to sign a new writing releasing the tenant. That, of course, would incidentally release the guarantor whose liability is secondary to the
I mean
tenant.
that this paragraph, this language would be unnecessary
It would be,
under the
well, it must have
reading
meant,
of the lower
I don't
court.
think it's a matter of being unnecessary. The parties had language in there. It must have meant something.
Well, you're arguing that under the lower court's reading, the guarantor's liability rises and falls with the tenants.
Yeah.
That's the nature of the guarantee, and so you wouldn't need this paragraph.
Well, why is it in there then, is my question. I mean, the parties put language in there that
Saying
was quite...
That's my understanding of your
Right,
argument.
exactly. The parties have language in there that's quite extensive, and the holding of the court below renders
Is there any
that
other work
language-
that the paragraph may be doing?
I'm sorry?
Is the paragraph only doing the work that you have argued, that it says good guy guarantee?
I
Is there
think so,
anything else
yes.
it may be doing?
It's all it is a limitation on the liability of the guarantor. It's an escape hatch for the guarantor. That if the guarantor causes the tenant to send a notice and get out...
Well, it is the guarantee, right? I mean, it's doing that work.
Yeah. Well, I'm talking
Oh,
about
I'm sorry,
the
was
portion...
there other language
I'm-
that the guarantor signed
No.
off on?
Judge, I thought you were talking about the portion of the guarantee which starts, after paragraph 9, it's a guarantor guarantees to
Right,
owner
right.
the payment of all accrued rent.
Right.
Actually,
All I'm saying-
if the reading of the court below was correct, it could have just stopped there. It could have said the guarantee guarantors to the owner the payment of all rent by the tenant under the lease, period. All that language that comes after about the tenant giving 30 days notice and getting out, what's the purpose of that language? The only purpose of that language is it's a limitation on the liability of the guarantor if the guarantor causes the tenant to perform those acts. That's the party's agreement. The holding of the court below is that, no, that language is superfluous. It doesn't mean anything. It's without effect. And that's
Because
contrary
if
to...
the tenant is off the hook, so is the guarantor.
Well, I would say it a little differently. That's correct. What I would say is the guarantor is only off the hook if the tenant is off the hook, meaning that this guarantee, I'm sorry, guarantor, but this guarantee, which you thought was a limited guarantee, and which the landlord in its complaint alleged was a limited guarantee, is a full-blown guarantee. The tenant's and the guarantor's liability is coextensive. The tenant and the guarantor are only off the hook if the landlord, no matter what the guarantor does, whether he follows the procedure or not, if the landlord thereafter elects to sign a new writing releasing the tenant, and thereby incidentally the guarantor. That I would say subverts what to me is the obvious intention of this language, is to create a limitation on the liability of the guarantor and make the liability of the guarantor different than the guarantor of the liability of the tenant, which, by the way, the landlord agrees with, because they call it a limited guarantee.
Thank you.
Thank you.
Good afternoon. My name is David Rosenbaum. I represent the respondent, 1995 CAM LLC. Simply put, judges, your honors, there's no reason based on this record to overturn 76 years of well-reasoned contract precedent.
So can I ask you, I take it your reading is that until or unless the landlord consents, that the obligation of the guarantor continues until the lease is ended, is that right?
Correct.
Okay, so why use all of the verbiage in the guarantee as opposed to simply saying the guarantor guarantees all obligations, period? What about your adversary's argument that this is intended to limit the liability of the guarantor? Because it sounds like you're saying it doesn't.
It's a guarantee. Nowhere in, first of all, this guarantee is in a body of an amendment to the lease. So it's a lease, it's not a separate document. It incorporates by reference the original lease, which went back to 2004. So it includes Article 25, which we believe is relevant here.
Then what is
Not
the
Article
point
22.
of the 30-day notice requirement? What effect,
In
if any,
order
does...
for the guarantor to have been relieved of full liability and limit his liability to a certain point, the rent would have had to have been paid through the date that they gave notice, which was not. They would have had to return vacant possession, which we concede did happen, and they would have had to return the keys to the landlord, which did not happen. the keys were returned to the super.
So is that the reason that you're arguing that there is continued liability? I thought that you were saying that it was because there was no acceptance of the surrender.
That's correct.
Okay.
There's no written acceptance
Okay,
by.
so if that's necessary under your reading, it seems to me that perhaps it's not a meaningful limitation on the guarantor's liability, because it leaves that determination solely within the landlord's prerogative. But is that right?
I don't believe so, Judge.
So how is it a limitation if the landlord can continue to keep the guarantor on the hook by refusing to accept the surrender?
Because the surrender has to be in accordance with what the parties agreed to, and it didn't happen here. Let's just,
I understand that. Again, I'm just trying to understand something different maybe, which is there any way the guarantor can cut off liability if the landlord refuses to accept surrender? Or does, under your reading, the liability continue until the end of the lease?
because the language that's specific here requires a writing, unless there was an acceptance by the landlord of possession, there would not be a surrender.
Okay.
If there was a different writing, I think that was hinted to before, with more clarity, that said you would be released from personal liability beyond this point if X, Y, and Z happened.
Well, then, but
That didn't happen here.
That reading, as we were saying before, renders the language in this guarantee provision unnecessary and superfluous, the language about surrendering the demised premises. Because if you are correct, if we adopted that, you would never need this language. The guarantor is on the hook, right, until the tenant is released. I mean, why would you even have this language?
Because we want to make it clear.
If all this meant is, once the landlord accepts the surrender, the guarantor is released. Well, that was true without this.
Your Honor, you did not mince any words in Cooperative Central when you said that when sophisticated parties are charged with knowledge of surrounding facts and consequences of an agreement, they freely negotiate and assent. In this case, the language is clear. And then you went further in the Wu versus Ubertech, which was not a case involving sophisticated individuals. It was involving the ordinary consumer. And even so, you said that they still have an obligation to read the contract, and if they don't, they're stuck with the failure to do so. Ipso facto, here you had a
Right, so
sophisticated...
paragraph 25 says acceptance of a surrender. It just says surrender. So then perhaps the guarantee's sole reference to surrender means the offer of a surrender.
It says, shall be deemed an acceptance of a surrender. The cases, up until today, have always
Right, but
said...
doesn't that mean that there was a surrender?
It wasn't
Take
a
it or
surrender.
leave it.
In order to there to be, no, there was an abandonment, Judge. There's a great distinction here. Abandonment is a unilateral act. A surrender would be a bilateral act where the landlords are saying, okay, tenant, I agree to take back possession, and I'll do what I got to do.
Then why do you have acceptance?
That didn't happen
If a
here.
surrender, by its very nature, requires an acceptance, why do you need acceptance of a surrender? Why do you need that?
Judge, I didn't write this, but I think the intent of the language here, okay, is to make it clear that unless there's a writing that is received and written off by the landlord, you, guarantor, are not off
But then
the
why
hook.
wouldn't it be written that way? Because it seems to me, if I'm understanding you, you're arguing that the words pursuant to the terms of the lease are what do that work for you, yes? That require adherence to the
Pursuant
acceptance.
to terms of the lease brings us back
Yeah.
to 25.
Imports it, you're arguing, yeah. So why not simply write it as clearly as you just laid it out?
I agree. But nevertheless, there's no concession by the tenant that there was a writing. There never was. And there wasn't an acceptance of the keys.
No, I mean, why not write the language of the guarantee as straightforwardly as you just explained it to us, which is that the guarantor is on the hook until there is acceptance of the surrender in writing?
My understanding of the case law beforehand is that this language, "and as otherwise required by lease or in accordance to lease," requires a signed write-off from the landlord. Judge Canataro, in 2 lower court decisions, opined on that language the same way, and I believe that Judge Rivera did the same thing in the Central case. So I don't think we're deviating from that. We're basically upholding what has been
So
precedent for
why
76 years.
Why is the guarantee here any different, straight ahead of you, why is the guarantee here any different than a guarantee that just says, I fully guarantee all of the obligations of the tenant, period?
We'd have to know if that would be probably considered a full guarantee.
Yeah, and is this not a full guarantee the way you're interpreting it?
It is a full, however, if X, Y, and Z happened, then it would limit liability. But X,
Yes,
Y,
but
and
for
Z did
purposes of
not
a
happen.
surrender, that was the point before, for purposes of a surrender. If it requires acceptance for the tenant to be released, once the tenant is released, so is the guarantor.
But there was more that had to happen here. Can I just put in just 2 seconds for perspective? We're talking about November 2020 in the height of COVID. Commercial premises, the tenant wanted out badly. Okay, sends a letter, returns the key to the super, even though it's very clear that sending it back to super was not in accordance with the language of 25. More recently, the First Department in Elk 33 versus Sticky went so far as to say that the failure to obtain landlord's written acceptance of tenant surrender warrants summary judgment in plaintiff's favor, irrespective of the other conditions of the good guy guarantee were met, citing Sharapov. But here they weren't met. He didn't get a signed guarantee, sign off from the landlord, and the keys weren't returned to the landlord.
Well, all it says is that giving the keys to particular people, not the owner, doesn't constitute a surrender. It
That's
doesn't say
correct.
that anything else, right?
The key is that someone who's not the landlord has no authority to basically give up the landlord's rights under the lease. He can't dispute that the tenant is still liable. The end of the lease clause that he's referencing in his
I'm sorry, where does it say you have to give the owner the keys for a surrender to be effective?
Paragraph, one moment.
That's not in 25.
Owner's agent shall have, it's the last paragraph, no employee or owner of owner's agent shall have any power to accept keys of said premises prior to termination of lease, and leave the keys to any such agent or employee shall not operate as a termination of a lease or a surrender of the premises. It's
Right,
pretty clear.
Yes, but that doesn't mean that you have to hand the keys to anyone in particular this just means doing this won't get you a surrender.
That's right, but that's one of the conditions. If you go back to
Well,
Paragraph
let me give you a
9.
hypothetical. I'm the tenant, I've talked to the landlord, I said, I'm going to surrender. I want to get out of the lease, and the landlord says, I'm going to make double the rent if you go. I accept your surrender. And I say, okay, I can't leave until tomorrow, and the landlord says, I'm not around, and I don't trust you to give the keys to anybody, just leave it on the counter, lock the door behind you.
it would seem to me, based upon your set of facts,
Yeah.
if that's what the parties agreed to,
Well, it wasn't necessarily, all I'm saying is this writing says, giving the keys to someone else doesn't effectuate a surrender. Put aside whether or not it's accepted, that's a different issue right now. I don't necessarily read it as requiring anything, because I don't see where it says a surrender is not effective unless the keys are turned into the owner.
I understand. Your Honors, the respondent here argues that for some reason, the appellant is trying to conflate the words acceptance and surrender. There was no acceptance. We understand surrender to be what these courts and the appellate division have said long and many times, and that is, if it's whatever the parties agreed to in writing, in this case, it made fairly clear that it required a sign-off by the landlord. There wasn't one.
But it sounds like you're sort of saying that there was no surrender either. It's not just
correct.
it's not just the absence of the acceptance.
That's correct. My opinion, surrender is not unilateral, it's bilateral. The parties have to agree to take back
Yes.
full possession.
I understand. It's a unified concept. There can't
Correct.
be a surrender without the acceptance under the terms of this agreement.
Right, which
But-
You understand it as an offer of a surrender, and until the landlord, or whoever the landlord may designate, here, let's just say the landlord or the owner, accepts, it's not effectuated. It's merely an offer.
I would feel much better, Judge, if you didn't use the word surrender, but maybe
I
relinquishment.
don't know, that's in the, it's in the lease, I'm stuck.
Relinquishment of possession.
I'm sorry, what was-
Relinquishment of possession.
yes, okay.
Okay? And then the question is, what did the parties negotiate and agree upon here? Right? Here, it's pretty clear that the guarantor is not released unless X, Y, and Z was done. X, Y, and Z was not done.
The X,
here.
Y, and Z being, you make the offer, well, you
Not
surrender,
You-
the owner in writing,
You give notice of intent to
the
vacate.
owner in writing accepts, and I'm not so sure I'm persuaded, but I think you're arguing, and you turn in the keys to the owner.
Correct.
X, Y, and Z are the things that the tenant would have to do to relieve the tenant of liability as well. Is that right?
It's only the tenant. If the tenant does what he's supposed to do, then the guarantor is the
Yes.
one.
It's just we've been referring to them as X, Y, and Z, and X, Y, and Z are the things that the tenant would have to do to relieve itself of further liability.
Not the tenant. Tenant, in this case, is always would be, the lease wasn't over. The lease went on for another 3 years.
No, I understand, but what are X, Y, and Z then? Maybe I'm confused.
Okay. In order for the guarantor
Yes.
to have his limitation of liability,
Yes.
he, in this case, Mr. Gary Lieberman would have had to give notice, 30 days' notice.
Well, that's the tenant giving the notice. Mr. Gary isn't occupying it himself.
Correct.
The tenant.
Tenant give 30 days' notice, make sure the premises are returned in whatever the conditions were,
Right.
turn the keys to the landlord.
Those are the tenant doing those things, not the
And
guarantor.
then here it talked about payment of money through the date that they gave notice, which was not done.
Okay, but that's again the tenant doing that, right?
That's correct.
So it's WXYZ, I guess we've got four things. But if those things which are all done by the tenant had been done, which I understand you're saying they hadn't been done, but if they had been done, the tenant would then have no further liability?
Is that
Not
true?
the tenant, no.
No, but
No,
is
no.
that true? Because if all these things have been done, my understanding from the case law, maybe this lease is different, is that the tenant only is relieved of liability to pay the rent if the landlord relets it, right? And then they offset that amount that they're reletting.
This lease, the tenant walked out in the middle.
No.
The tenant is not relieved of
I'm sorry.
liability.
I'm not talking about this lease. I'm talking generally. If a tenant surrenders the premises, right, and they follow the rules, and they accept the surrender, the landlord accepts the surrender, my understanding in a standard lease is that they are still liable for their lease payments unless the landlord opts to relet those premises and can do that. Whereas the guarantor would be off the hook for liability once the surrender is accepted.
So under holy name,
Right.
only properties, there are the three options that the landlord would have, right? In this case, we never got to that.
No, I understand that, but just looking at the difference between the liability of the guarantor and the liability of the tenant, one thing that happens releases the guarantor, which is accepted surrender, no more liability. What releases the tenant is, yes, you have to do all that, but to get out of the money damages, it has to be relet.
Yes.
So that's what would trigger the commercially reasonable efforts to relet requirement.
What if the landlord chooses not to relet, the tenant wants to regain possession?
I'm sorry, I don't
You're not
understand.
going to relet, so I'll take back possession. I don't want to be paying rent if I don't have the benefit of the use of the property.
The, my
Must the owner allow them access and let them take possession?
Are you saying, you're saying that the landlord's going to allow the tenant back into possession?
Correct.
And treat the notice as a nullity? I assume the parties.
I don't know about that, whatever agreement they wish to enter.
Right, but in order to do that, you're basically saying that you're going to treat the notice either as a nullity or enter into a new kind of agreement.
Sounds like a
I can't
new
really
lease.
speak to that.
All I'm saying is whether, I'm asking you, could a tenant was properly surrendered, it's accepted, but the landlord now just says, I'm not making any money, I'm not going to get more money in rent if I relet it. I'm going to keep this tenant on the hook and have them pay. And maybe the landlord thinks they can actually collect from that particular tenant. Tenant says, well, if you're going to keep charging me, then I want the premises back. Does the landlord have to allow them into the premises under those circumstances?
If
If they're actually going to charge the tenant, as opposed to, I'm not going to relet, but I'm not going to go to court and try and charge this tenant.
No. Landlord can decide based upon the holy properties what to
Holy
do.
name.
Holy name property versus Kenneth Cole. Right. I don't think they have to. If the landlord wants to make an agreement with that tenant and put him back in and it works out and the parties come to agreement, that's fine. But that's not the facts here. The facts here is that the tenant
Yes, I
walked out
understand.
in the middle of the lease and the tenant's still on the hook. And the question is whether the guarantor should be relieved of liability for the future rents. And we believe since they didn't comply with the express language in the lease, the guarantee incorporated by the amendment, that the guarantor is liable. And we believe that the appellate division decision should be upheld.
Thank you.
Thank you, Judge. You know, this was a summary judgment motion, and the facts were undisputed. And it's undisputed that the tenant gave landlord the 30-day notice, as the tenant was required to do under the terms of the good guy guarantee. And that notice, by the way, said quite expressly, it said, pursuant to paragraph 9 of the Second Amendment, this is the notice from the tenant, guarantor shall be released from all obligations to pay accrued rent and other charges accruing from and after the surrender date. Landlord didn't start shouting at that point, send a letter back saying, guarantor is going to be on the hook. No, the landlord accepted that, didn't respond to the letter. And the tenant delivered the keys, and I don't know how you can deliver the keys to an LLC other than delivering it to some human being who's an agent of the LLC. But that's actually, the delivery of the keys under Article 9 of the Second Amendment and paragraph 22 of the lease, which governs surrender pursuant to the terms of the lease, doesn't even mention the keys. And we got into that before, but I wanted to clarify that. What Article 9 says is the tenant has to serve this 30-day notice and then completely vacate, free and clear of all subtenants and occupants, and surrender pursuant to the terms of the lease.
Paragraph 25 does talk about the
paragraph-
keys.
But I'm
Very
talking about paragraph.
explicitly. I know what you're talking about, but I'm saying that very explicitly here, it says, "No employee of owner or owner's agent shall have any power to accept the keys of said premises prior to the termination of the lease."
I understand, but what I'm saying is that when you look at paragraph 9 of the Second Amendment, and then paragraph 22 of the lease, which is the paragraph we say is what is referred to when it says you surrender pursuant to the terms of the lease. And I
I know it's
frankly
what you
don't,
say, but I think it would have been a lot easier if it was more explicit in this lease, but
well,
the
perhaps
greatest intention of what the parties want is what's written. And here, I don't see how you get around, there's no agreement to accept unless in writing signed by the owner.
we don't have to get around that, because we are not alleging that there is an agreement to accept. The absence of a writing signed by the landlord does not disprove surrender. Surrender is the tender of possession. What it disproves is the acceptance of a surrender, which has the effect of terminating the lease and terminating the liability of the tenant.
If you do not accept the, I won't call it the tender of surrender for the moment, you'll see why. You do not accept the tenant's offer of retaking possession, of giving up possession in an effort to be released from the lease. Isn't that just an abandonment? That's holy name. Holy name is not about surrender. Holy name is about an abandonment.
With regard to the tenant, perhaps, but with regard to the guarantor in this case, it is a fulfillment of the conditions of limitation in the guarantee. Those conditions were met here by the guarantor. And I should say,
Well,
paragraph 20
let's say we're persuaded, what you all intended was a surrender regardless of whether, right? An offer of a surrender,
that's
regardless of whether the landlord accepted it. But given, as Judge Sines points out, and I think several other members point out, that language is missing, aren't we then just stuck with the language the parties chose?
Well, the language the parties chose with regard to the manner of surrender, the only language with regard to the manner of surrender is in Article 22. Because Article 25 is with the no waiver clause.
22 starts off by saying upon termination of the lease.
That's correct, Judge.
Termination or expiration, which hasn't happened?
No,
Hadn't happened?
no, it has not happened.
So then
But
why
that's
is it
not the only time.
Then why
that-
is
that-
it control?
Because it's the only provision of the lease which governs the manner of surrender. And by the way, it also says at the end of that paragraph that the obligations survive expiration of the term, so it can be performed at times other than the expiration of the term. But that's the only clause in the lease that talks about the manner and the method of surrender. Paragraph 25 talks about the manner of acceptance of a surrender. So the absence of a writing, and it says no agreement to accept such surrender. That's very important because those words assume the existence of, quote, such surrender, end quote. And they say that no agreement to accept such surrender, which the language assumes exists.
Well, all paragraph 22 does is say, when you quit and when you surrender, you have to leave the apartment in this condition.
Right.
It doesn't, it would not mean you didn't quit the apartment. It mean you'll just be liable for the landlord having to pay to clean it up.
Well, what I would say is that the condition of limitation in the guarantee is the tenant surrendering pursuant to the terms of the lease. So there's two requirements. One is paragraph 22, and then there are the additional requirements in Article 9 of the Second Amendment, the guarantee, which says that it also has to be delivered free and clear of all occupants and subtenants. So that
Pursuant to the
requirement is
terms.
added to paragraph 22.
Pursuant to the terms of the lease. You keep omitting that. I think you're trying to make the point that surrender is standalone, but in the lease, surrender, I think, is only mentioned 2 times, and it's always in connection with something, surrendering the condition of the apartment and surrendering pursuant to the lease. It's not a standalone.
I think that's the whole point, Judge, and that's the issue that Your Honors have to decide. Because the question is, what I'm saying is that Article 25 doesn't talk about the manner of surrender.
Let me ask you,
it talks about
what is your strongest argument
well, I think
for why we should read something that otherwise is not really the language of the lease? Is it that it would otherwise render the guarantee, that language
Yes,
that we're talking about in the guarantee, superfluous? Is that your strongest argument?
I think so, Judge. I think that's the strongest part. And I would also say we have up here at least 8 very smart lawyers. I'm not counting myself. But we're going back and forth about the meaning of surrender and acceptance or surrender and acceptance. And I would say these terms are widely misunderstood, widely misconstrued among the bar, among the courts. And
Even more reason to have clarity in the
all the-
language chosen.
Well, all the more, I would say, all the more reason to respectfully request that this court give parties going forward some clarity about what surrender means and what surrender and acceptance mean. And
Well,
that
don't
will-
we only
best-
have to give clarity as to what it means in the context of this
Well,
particular
That's,
language?
yes, but
So-
this language, and I'm not talking about the guarantee, I'm talking about the sections of the lease, 22 and 25, are in the standard Real Estate Board of New York form that parties use all the time when they make
The
guarantees.
guarantee, you told me the guarantee language was not, and there you certainly
right.
could have put, or someone could have put, the surrender, even if the owner doesn't accept it. right? Or offer of a surrender, even if
I don't
not
think it's
accepted. However
necessary.
you wanted to write that.
That, I think, is the essential point. I don't think, to me, that language is not necessary because surrender has a meaning at law. And that's shown in the holy properties and centurion cases. Surrender is the tender up of possession to the landlord. There's no need in the lease to explain what a surrender means because the law tells us what a surrender means. It's just that over the years, some lawyers and some other people have gotten a little bit loose and casual
Well, there is a
about some
difference
of these
between
terms.
abandonment and surrender.
Yeah. Abandonment, no.
Even if you might do it in the same
No.
way.
I would say abandonment, a tenant is entitled to occupy his or her premises as it chooses. So if the tenant just leaves, the tenant is still on the hook for the rent. The
Sure, if
tenant
they're
doesn't have to
paying,
be,
if they're
but a surrender is the
officially
yielding up, dear Mr. Landlord, I hereby surrender. I'm out. Now the landlord can.
Or I just leave and never pay again.
That's an abandonment. That's not what happened here. We served the
No.
notice. The landlord didn't object, and we told the landlord what we were going to do. And by the way, Article 25, the no waiver clause, is designed to prevent a situation of a gotcha. You know, you deliver the keys to the super in the middle of the night. That's not what happened here. We sent them a notice 30 days in advance telling them exactly what we were going to do.
So
and then
keys
we
are
did
not a
exactly
requirement
that.
for the surrender?
I'm sorry, Judge.
Under that reading, returning keys are not a requirement
No,
for a
it's
surrender?
not returning the keys, and that's what I wanted to clarify
Related to
from
the
earlier.
acceptance.
With regard to Your Honor's question, Mr. Chief Justice, it's not, the returning of the keys, which we got into before, and is not set forth in Article 9 of the Second Amendment, and it's also not set forth in paragraph 22. They did it. They said, they sent the notice to the landlord. They did it. They got out. They delivered the keys. The super took the keys. They actually did a walkthrough.
But counsel, would you
all that is not
agree,
required.
would you agree that Article 25 is a term of the lease?
Of course.
So when you have the language that says pursuant to the terms of the lease, why is the title of the paragraph so dispositive?
Because there are a lot of terms of the lease that don't have anything to do with the issue that we're dealing with. And I would say Article 25 doesn't have anything to do with the manner in which a surrender is effectuated. It only has to do with the manner in which an acceptance of a surrender may be effectuated. No agreement to accept such surrender shall be effective unless it is in writing signed by the landlord. Doesn't mean that such surrender doesn't exist. In fact, the parties know it exists because they called it such surrender. But the agreement to accept the surrender can't be effective unless it's in writing.
Is there anywhere in the agreement that it says the tenant must present the keys to the owner? I read this
No.
in the negative.
No, I don't think so,
If you do this,
Judge.
that's not
I
sufficient
don't
for
think
a
so,
surrender.
Judge. It just says, the conditional limitation in the guarantee says what the tenant must do to get the guarantor off the hook. Not the tenant, the guarantor. The tenant did it. And that's the end of it. That's our argument.
Thank you.
Thank you.